Okay, well, thanks for reconvening all, wherever you are and in whatever time zone you reside. Glad to see you back. Our next speaker is Judge Shannon Metivier, who graduated from College of Law at the University of Saskatchewan in 1992 and was called to the bar in 1993. She worked as a lawyer at MacArthur here in Saskatoon until her appointment to the provincial court in Saskatoon in April of 2013. She is one of two judges that sits regularly in the Mental Health Strategy, MHS, court and is actively involved with the administration of that particular court. And the title of her presentation this evening is Mental Health Strategy Court, Saskatoon, Addressing Mental Health Problems that Lead to Criminal Behavior. Judge Metivier will discuss why Saskatoon needed a mental health court approach, the significance of the mental health conditions to justice, mental health strategy goals, and the MHS operations, community participation, and challenges that the MHS faces. Judge Metivier.
Thank you. And that's all in 20 minutes or less. I thank you for the invitation. I thoroughly enjoyed the first two presentations. I found them very informative. And I applaud the work of the province and of the Saskatoon Police Service that they're doing and their initiatives. It's always preferable to address mental health concerns outside of the justice system, wherever possible. I don't think anyone would say that the justice system is the ideal place to address mental illness. That said, it's unlikely that we're going to be able to reduce the offending to zero in our communities. So some people with mental illness will end up in the justice system, and that's where we come in. What can we do to improve what we're doing within our sphere in that area? It struck me as I was listening to the other presenters today that we all have very common goals. Ultimately, we all want to improve outcomes, we want to improve well-being, and we want to make our communities a safer place, and some communities where everyone fits in and does well. Tonight I'm going to provide a fairly brief overview of the mental health strategy, which we call the MHS, undertaken by the Provincial Court in Saskatoon, why it was formed, how it operates, and some of the challenges that we've noticed since we began our operations. The Provincial Court, which is where I'm a judge, is the court of first appearance for all criminal matters. Anyone charged with a criminal offense will make their first appearance in either an adult custody docket court, which we call bail court, or a non-custody docket court. These docket courts not only deal with first appearances, we deal with all procedural steps apart from trials or lengthy hearings, including pleas, sentencings. We handle all adjournments that happen between other procedural matters. There may be as many as 50 people on a docket. Add in the Crown, Defense Counsel, court workers, mediation workers. It's a very, very busy place. It can be intimidating for people without mental health concerns, and certainly, I imagine, more so for people who do suffer from mental health concerns. Individuals with mental health concerns are often charged as a last resort, and I heard that from an earlier presentation today, that the police, I think, do their very best to divert, to access community services, and it's only when those diversion measures fail or family is at their wits' end that people come into contact with the justice system. When an individual comes into a docket court, the court may have no information that the person is suffering from a mental health concern, or very little information. What information the court does have, we receive possibly from the Crown Prosecutor, Defense Counsel, if there is one. Oftentimes people are unrepresented or representing themselves. Sometimes the court may notice that the person is talking or behaving strangely. That's an indication, or can be an indication. However, people with mental illness may also appear very normal, in which case we don't have that signal that something is wrong. It may be that we're twigged that something is not quite right by a pattern of behavior, a new behavior that is present that wasn't previously present in an individual. So there's many things that can happen in our courts that is just to raise the issue and say, maybe there's something different about this person, something that we need to find out more about this person. It's fair to say, I think it was acknowledged that police maybe, things are getting better, but don't always have the training to deal with mental illness. And I think it's fair to say that judges, lawyers, we also don't typically have special training or knowledge about mental illness. So it's an area where we've had to get information from others who have been very kind and generous with their knowledge and sharing that information so that we can try to do a better job. You may be surprised that there's very little room in the criminal code to order assessments. Really, the only mechanism to order an assessment is Section 672.11, where the court may order an assessment of an accused if the court has reasonable grounds to believe that such evidence is necessary to determine fitness or criminal responsibility. Those assessments are there only to address those two things, fitness, criminal responsibility, and it's only extreme behaviors there that are noted or addressed. There is a provision in the criminal code to order pre-sentence reports in Section 721. It's not technically there to order psychological or psychiatric assessments, although we do use it as such, and I think that's where the section under which the MHS uses to order them, and we can do that because it's by consent. At that point where we're in the MHS, both the Crown and Defense are recognizing that we need this information and it's by consent. But to do it of your own initiative, we're really limited to the fitness and criminal responsibility assessment. Again, dockets we have people appearing often without a lawyer. Very brief interaction. When you have that many people in a docket court and people who work in the system daily, it tends to move very quickly and rather routine language. So it gets to be a pace between the Crown, Defense, the court, and things move along, and that's necessary in a sense because you have to get through your dockets or you'll be there to midnight. But mental health concerns in that environment can be easily missed. When the court is unaware of mental health concerns, mistakes can be made. The pre-sentence report is a document that's prepared to give us information about the accused person in preparation for sentencing. If we don't know about the mental illness and what role it played in the criminal activity, then the court isn't able to take that into consideration in sentencing. There are provisions in the criminal code that allow the court to take mental health into account, and one is the principle of proportionality, which says the sentence must be proportionate to the gravity of the offense and the degree of responsibility of the offender. So someone who is suffering from a mental health condition, that may serve to reduce their moral blameworthiness and therefore affect the sentencing decision at the end of the day. It's also can be considered as a mitigating factor in sentencing. So very important to have that information. Also, without information about the person and what their issues are, there's the likelihood that you can make court orders that are bound to fail, that people simply can't follow through no fault of their own. Failure to address underlying problems, resulting possibly in a revolving door to the justice system. You're sentencing, you're letting out because of the mental health condition, they're reoffending, they're back, and then the sentences are growing in severity each time because then they're repeating the offenses. And ultimately, the risk to the community is left unaddressed. So the goals of the MHS are up there. The first three goals are not unique to the MHS. They're sentencing objectives found in the criminal code. Really, what the MHS seeks to do is understand and address the underlying cause of the offending behavior, with the goal that the accused will leave the MHS in a better position with better health and support than when they came in. How is the MHS different from other dockets? And this is a work in progress, and since I've been, I think you heard I was appointed in April of 2013, and I didn't start to sort of sit in the mental health strategy regularly until September 2014. And since then, I've really seen the process grow. as people become more comfortable in the environment, there's a more collaborative approach and a willingness to share information, and you know, I think it's changing. We get out of those traditional silo roles of Crown defense and into a really problem-solving environment that we're there to say, okay, what can we do to assist this person, help them do better. So one of our goals is to create an encouraging atmosphere. We try to do that by slowing things down. Time and patience are key. It varies from one court day to the next, depending on how many people are on the docket. We encourage people with mental health conditions to come with support people. It could be a community worker, a family member. We encourage those support workers to speak to the court, share information if they feel comfortable. We try to engage our clients, you like that, in conversation, include them in the process. Because so often in court, there's, again, the fallback position is Crown defense, the court speaks and people are out. So really try to engage the people in the process and to accommodate, we're better able to accommodate any special needs they might have. And we've had a few occasions where people were just so anxious that they couldn't even attend court. So, you know, that was made known, and we made accommodation that they could maybe come at the end of the docket after everyone else had left, or something of that nature, or set a separate day for sentencing where the courtroom is fewer people in the courtroom, those kinds of things that we're able to do. One of our goals, of course, is to identify what the mental health or associated concerns are. We can do that. Sometimes there is information out there that we can collect, or we can order new reports, and we have a couple of consulting psychiatrists that we depend on to do that, Dr. Mela and Dr. Marcoux. Then what we want to do is develop an individualized plans to address the mental health and criminogenic needs. Again, that's a work in process. It depends on what information you receive in, how detailed the plan is moving forward. And I do see that, again, I think that it's improving as the court matures, and we start to see what types of issues are out there, and we're getting better at identifying those issues and finding ways to address them. We also want to, I think I heard this in an earlier presentation as well, it's not enough to then say, great, you've got a family doctor, you've got a psychiatrist, we've diagnosed you, you're good to go. We want to look at how do we then transition from the court process into the community, so that once they're out of the court process, hopefully those community supports can continue moving forward. And finally, as well, we're working on, we're doing all this research for future needs and growth, and that's this very organization that has started that process for us so that we can grow based on the evidence, real evidence that is collected as we move forward. We're always concerned about balancing privacy with sharing. We address that through, first of all, entry into the mental health strategy is completely voluntary. No one's forced to be there. And we obtain reports with the person's consent, and we share those reports with that person's consent. Our first MHS docket was on November 18th, 2013. Modest goals to get it started. Judge Sheila Whalen started the court, and her idea was, it was obvious we had a lot of people coming to our court with mental health concerns. She said, well, why don't we filter all those people into one courtroom? We're having court anyway. Let's just filter everyone who we believe have mental health concerns into one courtroom. And then she said, and I'm going to invite community agencies, government agencies to the court so that we're all in one place to have this conversation together. And her invitation to the various agencies was met with a lot of enthusiasm, and we had a great response, and we still do in terms of the community agencies and government agencies that support our court and come each and every week. Our court is 2 Mondays mornings a month. So anyone who's familiar with how slow justice moves, I'd laughed. I was commenting earlier, I'd have the media want to do interviews, and it had been 3 months, and I'd say, you know, that's only 6 court days. Nothing's changed. Currently, our eligibility requirements are very broad. And again, we wanted to encourage as many people to access the MHS as we could. I think at the start we were worried about having no one there, and that hasn't been how it's turned out. The eligibility requirements is that it must be someone who's willing to accept responsibility for some or all the offenses, because it is a sentencing court. Must have a mental health diagnosis or suspected of having a mental health condition, which can include a cognitive condition that played a role in the criminal acts, and must be someone who's out of custody. Again, their participation is completely voluntarily. We encourage a collaborative team approach where we have pre-court meetings to discuss case management and progress, and the goal of the court is to postpone sentence so that we can facilitate that assessment and case management before sentencing. Addictions is not the focus of MHS, but has been mentioned in previous presentation. It's often linked with mental illness, so we just can't separate the two. We don't have any specialized addictions program, but we do frequently access mental health and addiction services to get that support, because we just find that the two are often linked in our court. This is a snapshot of our MHS team, and I see some here tonight, here to support me or give me heck after. It includes the judges. I think we mentioned 2 judges. We're going to get a 3rd on board this coming year to help out with it. We have Crown, of course, legal aid. We have a nurse with mental health and addiction services, FASD worker, and I see her here tonight. Probation officer is also here tonight. Social services, other agency advocates who come with specific clients from time to time. I have seen PAC there, I've seen Crisis, I've seen Acquired Brain Injury, Elizabeth Fry, all sorts of agencies come. They can't be there all the time necessarily, because as we've all talked about, ultimately we were streaming in and relying on our community resources. So those people, they have wings, they're angels, but they can only do so much. But I found that they certainly are there when we need them for their support, and have been very helpful. I wanted to tell you a little bit about our pre-court meeting that happens on docket day. Again, I mentioned before, we have court 2 Monday mornings a month. We meet at 8:30. That's not really the beginning or how things start, because our docket is distributed to all our team members before docket day. So each of our team members has the names of the individuals who will be on the docket that day. They all do research in advance of coming to court. When they come to the pre-court meeting, they all have a wealth of information to share. Is this person connected to services, or are they not connected to services? Are they aware that they were diagnosed or not diagnosed? How are they doing in the community? Are they stable or are they not stable? And that's where we get the information then that can form our planning part of our process. After the pre-court meeting, then we have our regular docket, and by then we already have an idea of what we kind of expect to happen that day, so that it's hopefully a more organized session. There are challenges. I'm not going to say there's not. There's growth, but there's also challenges. Ultimately, we're looking at stability. We see housing as a common thread that is lacking. Income, social services has been helpful on both those fronts. Addictions is a common thing common issue that we see in our court. Occasionally, some of the people, there can be a lack of insight, and because it's a voluntary process, it can be frustrating at times. And I had I don't know if my team members, but there was one day it was a perfect opportunity in our court, because someone had said, we were encouraging them, or telling them, you can go and get services here, you should go make an appointment. And they said, well, I thought this court would be easy. We said, no, it's not easy. It's a court where we help you help yourself. But unless you're willing to undertake that road, then there's frankly nothing we can do to help you. So it's really a place where we want to encourage people, support people, help them themselves. And something I like to continue to work on is to get people to take personal responsibility and ownership of their own plans. So rather than telling them all the time, we think you should do this, what do you think the issues are that you need to address, and what is your plan to address those issues? Because I think the more we can do that, then hopefully they'll get more involved and take ownership of their own plan to recover, get better, get well. Some simple things like transportation. You know, it's funny. We've had government support and they pay for the reports that we order, which is very much appreciated, and it's a big component of what we do. But something as simple as getting transportation to for those assessments can be a huge stumbling block because they don't have a way to get there. So simple things like, you know, I really had to, it was an eye-opener for me to just go down to the very basics about your appointment is at 2 o'clock. How are you going to get there? Who's going to take you? You know, that kind of thing, because we're used to just saying, ordering an assessment and it's done, but you have to really take care to look at the details to see that things go smoothly. Our fear of not having anyone come to our court was for naught. There was no reason to worry about that. The biggest problem we've had is, I'd say, a victim of our success. We typically have about 60 people, I'm going to say, like it varies, but about 60 people in MHS at any one time. Mental health courts in other jurisdictions tend to operate with fewer than 20 participants. And those mental health courts also typically have case managers. I think in Nova Scotia they have a nurse, social worker, addictions counselor who create or design the management plan. So I would say that I know we've had our first review done. I'll get to that in 1 minute, but this is just some of the feedback. I mean, certainly we've had some challenges, but we've also had some successes. Some comments from people coming to our court. Can I give you a hug? I like coming to court. Without MHS, I'd be dead. Not everyone is so positive, but we didn't left those out. Positive comments from team members and from people outside also saying, how can I get involved? How can I help? Which has been just fantastic. So this is our research evaluation, which was done by this center, which I can never say the name in full, Center of Forensic and Justice Studies, which is up there, but you can go on their website and read more about the MHS than you probably wanted to know. But the main challenge that was identified is the size, that you know, you can do more with more, but we don't have more, so we have to learn to do the most we can with what we have. And I think our challenge is to really reduce the number of participants we have in our court so that we can get more involved in their case management. So moving into 2016 now, I guess, that's what we're looking to do. And I heard someone say in one of the previous presentations about borrowing or stealing plans from other jurisdictions. And that's what I'm hoping to do. I think it was actually Professor Wormuth who had sent me the Nova Scotia review, and they had a little more stringent screening process, I would say, to get into their court and approval by the team. In a way, it's unfortunate because you want to help as many people as you can. But I think with the resources that we have to do justice to the people that we accept into our program, we really have to do a more screening about people who are really at a point in their lives that they want to make changes and are willing to work towards that change, and that the team feels that this is someone that we think that we can help move forward. And so we're going to look at some more stringent screening to reduce the numbers and hopefully increase the degree of individualized planning that we can do for each of those individuals, hopefully moving into 2016. And that's it. Questions?
Yes, any questions for Judge Metivier? And it looks like we have Dr. Nikolajchuk phoning up to mic number 2.
I'm afraid I'm going to have to complicate this picture somewhat. I spend most of my practice evaluating people for dangerous and long-term offender hearings, as well as less critical criminal proceedings. And over the last 20 years or so of doing this work, pardon the language, but I'm not seeing a lot of people who have IQs that go anywhere near room temperature, and they don't get recognized in this screening. They get accused of lacking insight because they don't understand. They get accused of being non-compliant because they don't understand. And I guess my question is there any part of your strategy or your initiative to address that problem? Because at least in my practice, and this is of course anecdotal, those people are somewhat larger in number than people who would be, formerly mentally ill.
Our eligibility for the MHS does include people with cognitive impairments. Sometimes there's information that we can obtain from youth files where people have had FASD assessments, for example, that we can access. Where that's not, then we can also order those types of assessments for adults. You're right, oftentimes that information is missing, and that when you receive the information, it really doesn't inform a lot about the person's history, doesn't it? When you're giving them conditions that they simply can't comply with because of their cognitive disabilities.
Usually a marker is an extensive history of low-level, really stupid crime.
Yes, and I've asked some people that sometimes, you're just struck by, but why do you keep doing the same thing again and again and again? And the answer is, I don't know, right? And so you have to dig a little deeper and find out the reason for that.
Yeah, so at least in my mind, the requirement is therefore to be an increase in external support to make up for the lack of internal management capacity.
And I want to just, again, maybe give applause to Ali Lukey and the FASD network here. They've been very supportive of our MHS, and that's exactly what they do, is provide support to individuals with cognitive disabilities to assist them in their daily lives. They arrange transportation to appointments. They've been a huge assistance to some of the people in our court. But I agree, support is key. It's not always available. It's nice when it is, if you're diagnosed with FASD, but if you're not, then that support can be missing. So there are holes, and maybe that's through our research, maybe we can identify some of those gaps in services as well.
And just to add to that, the FASD network was instrumental at the very outset in with Judge Whalen in initiating the whole MHS concept.
Yeah. Yes.
Yeah, as I interpreted your criteria for eligibility, the one that said the person must not be in custody struck my attention. I'm assuming that means people who are being held in remand can't participate in the program, and I was just wondering what the logic behind that is.
Well, the logic is because we rely on them receiving community services, and if they're in custody, then that's, we're connecting to community services, so it doesn't work for someone who is in custody, and that's the logic. It's not to say that people with mental health issues in custody don't deserve, there should be awareness and addressing their issues as well, but we're just not able to address it in our court.
Sure. Actually, our moderator held questions for the two presenters, so had a question for Mitch.
Okay, well, let's, if we can reconvene our
Okay.
three speakers and carry on with an open panel presentation, and so you can proceed with your question as Mitch gets to the table. Thank you.
Yeah, so in interest of disclosure, we have a family member who has some mental health issues at the moment and has had some encounters with the police, and starting with the justice system and the courts. And you mentioned, Mitch, that there was some kind of communication, there would be communication within the police department, or I needed a little more clarification on that. Just to give you a specific example, we had, back in the spring, we had arranged to have a mental health warrant issued for this person. and they were taken in, our family member was taken into the hospital, and of course it didn't really go anywhere. Within a matter of a couple of months, he was picked up by the police again. And now he was accused of impaired driving. And you had mentioned that you looked elsewhere for examples, and you made mention of South, and I'm assuming you meant the U.S.? I don't, sorry?
Yes, I did.
Okay. Yeah, because what happened in the situation is he's accused of impaired driving, goes down to the police, take him down to the police station, and now this is what really makes my blood boil. Apparently, the Saskatchewan police are getting drug training to do assessment of drugs, and if someone's on drugs down in Arizona. And so he goes into the police station, and they bring this specialist in and says, oh yes, this person's on drugs. So the net result of what happened there is that he loses his employment, he's close to losing his housing, and still being dragged through the courts. But we firmly believe, and currently waiting a talk screen, but firmly believe that that's going to come up as a negative. The disclosure was, there was nothing there. We've been over this with our defense lawyer. So I guess I wonder how could that happen, that a person could be picked up, the family's trying to support him, and do the route of the mental health warrant, and then within a matter of no time at all, he's really suffering because of his interaction with the police. So perhaps you could comment on that, or.
Without knowing more specific details of that, it's difficult for me to say, yes, I understand why this happened or not. I'm going to start with, my reference to the research and the examples down in the States, because you went there, and then, it's what you're referring to is drug recognition or DRE training. And the only place that police agencies across the country get that is down in Arizona right now to become drug recognition experts, as they say. So just on what you've suggested is that, the impaired driving, I would only have to start with an assumption, and that assumption that there was some driving behaviors that drew the attention of the police. And
Bumped the curb.
Sorry?
That's the disclosure was that he bumped the curb.
Okay, and I mean, that would only simply, in my view, be one sign of impairment. And one of the challenges for police today is there exists no effective measure if there's a suspicion of drugs alone for driving behavior. Our traditional driving behaviors response is, when a person's been drinking, and there's a couple of different measures of the intoxilizers, the breathalyzers, the roadside screening, but we rely on training of different people who have more training in drug recognition to then go to the next step in terms of determining whether someone is impaired or not impaired. I haven't seen a disclosure. I'm saddened to hear that your son is in danger of losing housing, and I think you said employment over that, and I'm not too sure why that would happen as a result of an impaired charge. Does that have something to do with
you
driving?
Can't drive. You can't
Okay.
drive, so you can't have an
Or
employment.
license.
Yeah.
Okay, and yes, without seeing the details or seeing the disclosure, and even seeing the disclosure, the charge is based on the reasonable probable grounds to believe that someone is impaired by alcohol or drugs, and that's the police standard. The next standard goes to the Crown, and that is there a reasonable likelihood of conviction based on the reasonable and probable grounds and the evidence, and eventually in Her Honor's court potentially. And in your case, I would have one of my wishes was that we could get to the court basis quicker, so that doesn't have the effects like it's had for your son as well. But without seeing the more specific details on that, I can't comment much further. My one comment about why I don't often look at the states is that they often don't have a lot of co-response models. They have a lot of what they do in the states is they refer to as the Memphis model, where they give police officers some additional mental health training, but they don't have a lot of co-response models. And I attended the mental health conference 2 years ago in Toronto, and a professor from the University of Chicago said part of the reason is because they have there's such a violent society and high propensity for firearms that it's riskier to have a co-response model down there than here. But I'm hoping that through additional training of police officers that we're getting now, that we'll have a better outcome for your son. And I can only suggest, without seeing the file, that they based that charge on their reasonable grounds to believe that your son was likely impaired by drugs.
Yeah, and I do want to say that certainly working with the PAC team was a positive experience. I mean, those people really seem to understand, and they working with I guess the social worker or the crisis group, whoever it was good. Now going to the hospital and then that's another whole story. But
and it would be likely more positive outcome if we all had the level of understanding about mental health that our crisis workers have,
Right.
and that's part of the value of the response, or a police officer like Jeff.
Yeah.
I think he'd be more attuned to.
Yes, his name was
Right.
raised in that incident, but I didn't hear the answer. So that there is no connection there. So if there's a mental health warrant, then the rest of the force doesn't know about it a month or a week or 2 months.
Certainly they do. There's a report on
okay.
on our system about a Mental Health Act warrant. So, would an officer had an opportunity to look on our system and find out that was a previous contact? Yes. Could that influence their grounds? Yes. But we've also heard, I think, in a number of our presentations today that there's concurrent disorders, mental health and addictions issues, and a driving incident that hit a curb draws a police officer's attention to that, and certainly armed with that much, the previous fact that the person had a Mental Health Act warrant should play into that overall decision, but the officer is faced with what is happening now, and what do they believe on reasonable and probable grounds is happening right now.
Okay. Thanks.
Thank you. I wonder if I could impose on our three speakers to reflect a little bit about their colleagues to their left and right with respect to their presentations. Fern, your presentation was a broad overview with lots of policy-related implications, and Mitch and Judge Métivier's were more on the ground level. How do these three perspectives relate to one another, or do they?
So hopefully someone from the audience has another question to bail us out of this general one fairly quickly. Excellent, great.
You need another minute. Mine was directed toward the inspector, but you might be able to help him out as well. You talked about the success within the Saskatoon police, but do you know, as part of your conference goings or whatever, if the RCMP is going to be implemented, or the OPP, or even the Aboriginal police forces, as in the smaller communities? Do they have the supports and the services to be able to do that?
Yeah, I really glossed over that in my presentation. I think I already went overtime on it, so I wanted to cut certain aspects short. And you know, it's interesting that we went on global studies and even some of the people we met with. In fact, the people we met with in Norway said, well, why are you here? When we look for innovation, we look to Canada. And there's a lot of innovation going across the country right now. Vancouver has something called CAR 82, and really CAR 82 is a co-response model that they've had since I think the 80s sometime. And they also have a sort of crisis teams, a sort of outreach teams. So, you know, they've got a long history of some interventions and some collaborations. So they've moved along quite nicely. And then, you know, if you look at Alberta, Red Deer, RCMP, Grand Prairie, Calgary, and Edmonton Police Services have. I'm not aware of anything in Manitoba. Ontario, Hamilton has. Montreal, Halifax has. Not aware of nothing in anything in the north. I mean, there was a question earlier about rural, and the interesting part is, you know, southern rural is a lot different than the northern rural, and policing or responding to people in crisis in remote areas is a lot different as well, because really the people in remote areas have less access to service than anyone else. And it's interesting is that in the month of October, there was a team from the Devon and Cornwall Police Service here from the UK that came to speak at a care and custody conference here in the city, and you know, they referenced our PACT model as the gold standard. And I mean, I took some pride in the fact that, hey, they looked at what we were doing and called it the gold standard. And I think really what they're getting as the gold standard might be a co-response model. But, I mentioned in my presentation, is that there has to be a model that's right for a community. And in Devon and Cornwall, what they do is from their control center, their command center, they actually have a mental health nurse responding in a police command center and giving advice to police on the streets, giving advice to the clients and so on. So is that a model that we could embrace and potentially have in the rural communities of Saskatchewan and the northern Saskatchewan? I think it is.
Okay, thank you.
Oh, good. Do I get to ask my question again?
Yeah, I can take a go at it. I guess just to say for myself, I was asked to start leading this review in June 2013. And before that, I was on the board of the Mental Health Commission of Canada for about 6 years. So I am just so delighted at what I see as the progress in our province over that sort of 7-8 year span. I mean, really, we weren't having these kind of conversations, at least not as far as I knew a while ago, and we certainly weren't having these kind of programs actually operating. So I was delighted to hear about the specifics of both of the programs, and just really excited about what's happening in our community. I think the conversation is great and the action's even better. So very happy about that.
I guess I'd just like to reiterate how valued and important the people are who are providing the work on the ground and the work that the province is doing to identify where the gaps are and where more services are required. PACT, MHS, we're really referring people to those services. So unless those services are available and there's people to do that work, then we have nowhere to go. So again, thank you to those people who do the work on the ground.
And I'm going to echo that point. I think, you know, the police and PACT and the courts, mental health strategy court, we're still downstream. You know, what's happening upstream, and those upstream interventions help us before they get downstream. And what supports are there in the community? You know, what capacity is there for non-government organizations, for community-based organizations to be part of the picture? And I think that's the strength. But I think it's multiple interventions. You know, we're doing ongoing evaluations of PACT, and you've seen some of the data, and we're still looking at other ways to evaluate it. Mental health strategy courts going through an evaluation, and you know, some of it could be the chicken and the egg argument too. Is mental health strategy court helping PACT? Is PACT helping mental health strategy court? I think we're helping each other, and the more collaboration we have in this community, I think the community is better for it.
Can I ask both Mitch and Judge Metivier about your current capacity now? Do you have waiting lists? Are you having to juggle things? How do you accommodate that? I'm not sure if with PACT, if you have 2 calls at the same time, do you flip a coin? How does that work? And where might the future go with respect to your capacity to serve?
Well, I think I'll start here in terms of PACT. I mean, I think we would triage to the call that seems to have the greatest need for an PACT intervention. But I think one of the not really intended consequences of PACT, but one of the things that's happening is that our members that aren't part of PACT are seeing how PACT handles a call, and they're becoming better at managing a call than maybe they were in the past. So I think that's happening. Would it be great to have 2 more PACT teams? Well, sure, it would be. Calgary and Edmonton, I think, started with 2, and I think they're at 5 and 6 or something like that. So where are we going to head in the future? Maybe we'll head in that direction. I'm not sure. I mean, that's why we're gathering evidence. We're trying to inform where we might go in the future.
Well, I think I already mentioned we're downsizing already, but that's not to say that we're growing we are growing in a sense as well. We're open to new opportunities, and I think that as we are in operation for a while and collect some research, there's other possibilities that the courts might look at in the future, or the province might look at in terms of diversion. Are there some cases that don't need to go through the court system at all? Can they be diverted, which requires the Attorney General's consent and all sorts of things? But the research that comes out of this endeavor, or the information that does, hopefully will lead to new, exciting, and different ways of operations as well. So we're downsizing, but we're not stunted. We're still moving forward.
And that leaves the last few minutes to myself. Thank you. To begin, I want to thank all of you in this theater and beyond who have shown your interest in our topic this evening. Whether you are academics, researchers, practitioners, students, bureaucrats, or those with lived experience, we hope this public forum has been of interest and value to your work and to your personal lives. Secondly, I want to thank a number of groups who have been helpful in both in terms of financially and other ways to make this forum a free and accessible event, both to the local community and beyond. They include the Correctional Service of Canada with respect to a memorandum of agreement that we, the Forensic Centre, have with CSC, as well as the College of Arts and Science, the College of Law, and the College of Nursing, all here at U of S. Finally, I want to thank our 3 speakers for sharing their experience and for offering their insight to the important and complex issues we face when those with mental health problems run in contact with the justice system. I trust that you will agree with me and that these are 3 silo busters who are challenging and championing our addressing of the mental health and justice landscape, 1 tree at a time. Oh, trees. I forgot. Speaking of the changing landscape, I'll ask each of them to come forward here to receive a small token of our appreciation, a piece of art from our own Professor Don Cooley in the English department. So please, indeed, come forward. Now, we're not really very high-tech here, and we could only afford 3 of these. But I trust that you will get the picture, that yes, indeed, you can now visualize our changing prairie landscape. Okay, can we cut now? Thank you. night, everyone. Enjoy.